Hello and welcome to a special interview for the Wire.in. For several months now, the Supreme Court seems to be in a state of turmoil. Whilst the judges have been writing letters to each other, exposing their differences, holding press conferences and even giving interviews, the Chief Justice himself has kept an inexplicable stony silence. And this has led many to the conclusion that perhaps the Supreme Court is in a state of crisis. With me to discuss this situation is one of India's most highly regarded former judges, former Chief Justice of the Delhi High Court, as well as former Chairman of the Law Commission, Justice A.P. Shah. Justice Shah, let me start with a simple question. Is the Supreme Court in a state of turmoil, approaching crisis, or is that an exaggerated perception?
I don't think it's an exaggerated perception. Supreme Court is certainly in a great turmoil, and I believe that the present CJI is partly responsible for this. There are many issues like the master of the roster, the allocation of work to different benches. Then there is also issue relating to MOP. Then the recommendations made by the Supreme Court of Indu Malhotra and K.M. Joseph are not being responded to by the government. These are, a very volatile time, I would say.
I'll come to each of these issues one by one, but would you say collectively they suggest a sense of crisis?
Yes, I would say that there is a in current situation, I would say that there is a crisis in the Supreme Court, no doubt about it.
Let's then start with the master of roster issue. Twice in the last 6 months, the Supreme Court has ruled that as master of the roster, the Chief Justice of India has an exclusive duty and authority to constitute benches and allocate cases. Would you agree or would you differ?
I would partly differ. See, the CJI claims, or I would say that the judgments lay down that the CJI is the master of the roster. He has unbridled power to allocate the work to any bench or any judge of his choice, and he has to be trusted. The problem is that his own colleagues are not trusting him. First we must understand that the Chief Justice all across the world, Chief Justice's position is regarded only as primus inter pares, that is first among equal. Now there are various systems developed in different countries to ensure that there is some procedure which would ensure a neutral case assignment, which according to me is not happening. And I can give you several instances.
But before you do, let me take you up on this primus inter pares point that you just made. In its most recent judgment on the matter, which was actually on the 11th of April, just 6 days ago, the Supreme Court described the Chief Justice as an institution in himself. And they said, whilst he is primus inter pares as a judge, in the discharge of his other functions, the Chief Justice of India occupies a position which is sui generis. Would you accept that on the administrative side, the Chief Justice has special powers and prerogatives? Because that's what the April 11th judgment is saying.
See, a Chief Justice, not necessarily of the Supreme Court, I would say even the Chief Justices of the High Court, apart from their judicial work, they perform some official functions. Chief Justice provides intellectual leadership to the court. He also, allocate the work to different benches. Then he recommends the names for appointment to the judges along with the members of the collegium.
But on this administrative side, does he have special powers?
He has a special power in the sense that in a court where there are multiple benches, like in US it is and all the judges sit together, where there are multiple benches, the power to assign the work is always with the Chief Justice. But the Chief Justice is expected to discharge this function in a transparent, fair manner. I can give you several examples.
Not arbitrarily, as he wants.
Not arbitrarily. And this very idea that he has a sole discretion to allocate the work to a judge or bench's choice is not correct. I can demonstrate this by taking you through some of the practices in other countries. I mean, I don't agree with this proposition that he has unbridled and he is unaccountable as far as the allocation of work is concerned.
Once again, let me quote from the April 11th Supreme Court judgment, because that judgment comes to the conclusion that the Chief Justice's powers are unbridled, exclusive, and can be exercised in his discretion as he wants. That judgment of April the 11th says that the Chief Justice's power to constitute benches and allocate cases is a safeguard of the independence of the Supreme Court, which is why that power cannot be diluted and it cannot be shared.
No, that's not correct. This is not how this power of the Chief Justice should be perceived or looked at. See, Chief Justice has to discharge this function, but it has to be done in a consultative manner or in a more transparent way. For example, I'll just...
He cannot do it on his own, of his volition.
No, on his own he may do it, but it is always there has to be culture of trust, like UK, where the power is exercised by the President and the Deputy President. I'm talking about the US Supreme Court, but that power is exercised following certain convention. It's not as you said, unbridled discretion to allocate the cases.
You make this point very powerfully in the B.G. Verghese Memorial Lecture you delivered earlier this year. You point out that in the UK and in Australia, the power to constitute benches and allocate cases is exercised consultatively, not as one man himself deems fit. And you also point out that at the European Court of Justice or the European Human Rights Court, this power is exercised by virtue of laid down rules which are widely accepted. In both these instances, there is no unbridled power with the Chief Justice. He cannot be the absolute master of what he wants. Do you think a similar practice needs to be followed in India?
Of course. We need to introduce this practice. Now, we cannot develop conventions at this late stage, but surely the judges can discuss this. All judges can sit together. They have a power to frame rules for the Supreme Court. So the rules can be laid down, giving clear guidance in relation to the allocation of work to different benches.
So you believe rules need to be laid down, which will guide the Chief Justice how to A, constitute benches and B, allocate cases to them.
For example, I mean, the International Bar Association delegation visited Russia. Now they found that the work is allocated to benches without any objective criteria, and the benches are packed to get a desired result. Now, do we want to be, in company with this kind of practices, or should we evolve?
Your fear is that if you don't have rules, the Russian practice could be happening in India, and we don't want that.
Of course, we don't want that. And
so the object of rules and the object of conventions and consultation is to ensure that arbitrary allocation of cases does not happen, that there is a rationale that is widely acceptable.
You can formulate rules. For example, in European Court of Justice, the seniority and rotation are the criteria. In European Court of Human Rights, the criteria is, seniority in the reverse way, alternative way. So they will take first the senior most, next the junior most, then the senior most, again the junior most.
But in both cases, there is a system.
There is a system. Just one more example. In federal court in US, it is done on random basis. It is not left to the discretion of one person. I'm afraid. Any power which is absolute and which is where the person is not accountable would lead to some arbitrary practices.
And this is where you disagree both with the November bench and the April bench of the Supreme Court, that in India, the exercise of the power of creating benches and allocating cases is given to the Chief Justice on an absolute, unaccountable manner, and you disagree with it. You believe it needs to be systematized.
Of course, it needs to be systematized, and it's not difficult. I'm not sure whether the present incumbent is going to do that, but Justice Gogoi, who was one of the 4 judges who went to the press, surely he can think of introducing some reforms in the system.
That's for the future. We have to first wait and see whether Justice Gogoi will be appointed
Of
Chief
course.
Justice or whether he'll end up paying a penalty for the fact that he was one of the 4 outspoken justices. But let me put this to you. Was it fitting and proper for the Chief Justice, the present incumbent Chief Justice, to preside over both the November bench and the April bench when they were in fact determining his powers as master of the roster, given that they were determining his personal powers, which he acts and exercises as the incumbent Chief Justice? Should he not have recused himself instead?
See, I find that this conflict of interest issue is repeatedly, is arising in the allocation of work in Supreme Court. The first, I can give several instances, but the one about that Kaliko Pul's case, where his widow made an application on the administrative side for a permission to file an FIR on the basis of that his suicide note. Now, the allegation was against the then Chief Justice of India, Justice Kehar. Now, he took up the matter, converted this into a writ petition, and assign it to a relatively a junior bench.
And you're saying that given that the matter concerned him, he should not have taken it up. Similarly, given that the master of roster controversy concerns the present Chief Justice, should he have presided over either the November bench that handled the matter or the April bench, or should he have recused himself?
He should have recused himself. And just see how this, the November bench, that was constituted, and that was a 5-judge bench, no? That is November bench.
Overturning a decision taken 24 hours earlier by
that's
Justice Chalameshwar.
Correct. So that bench was constituted in a great hurry. Then there were supposed to be 7 judges. The 2 judges did not join the bench. I was told that the 7 chairs were laid on the days, but the 2 judges did not join, and finally this matter has been decided by 5 judges. Presided over by the Chief Justice. Surely these matters ought to be, again, it was a case of conflict of interest. When CBI files a case saying that some former judge is involved in some conspiracy to bribe judges in Allahabad High Court and the Supreme Court, surely this matter should not have been taken by the
You're making 2 very important points there. First of all, you're saying there was a clear conflict of interest and the present Chief Justice should not have presided over the benches. But you're also saying this matter shouldn't have been handled in the hurry in which it was. It should have been handled in a more considered manner. That hurry itself was wrong.
Of course it is wrong, and I'm surprised that even in the recent judgment, they have not looked into the practices which are followed abroad. It's just a reiteration of the November judgment or the previous 5-judge judgment, where it has been held that the Chief Justice is the master of the roster.
So the bottom line is, Justice Shah, you don't think very much either of the April judgment or the earlier November judgment. You think they're just simple and straightforward. They don't look into the matter with the requisite research and detail and analysis that's needed.
No, I found these judgments very inadequate, and it's a very simplification of the scope of the power of the Chief Justice.
Let's now come to the letter that the 4 top judges of the Supreme Court wrote to the Chief Justice in November, which was released by them at an unprecedented press conference in January this year. Before I come to the content of that letter, I want to put this to you. One of the impacts of that letter was that the Chief Justice has started the publication of the roster. But it emerges that all PILs are still with the Chief Justice. All appeals from PILs handled by High Courts are also with the Chief Justice, and all accountability matters are still with the Chief Justice. So what do you make of this publication of the roster? How adequate is this?
No, I don't think it is adequate, A. And B, that it's merely a knee-jerk reaction to the criticism of the 4 judges, that there was some arbitrariness in allocation of work. So this is not, he's going to hear, just consider this, he's going to hear all the PILs in the Supreme Court, all the appeals against the order passed in PILs by different high courts. Or he is going to assign it to a particular bench.
So this is inadequate.
This is inadequate.
It's an ill thought out response.
See, I compare this with the allocation of work in the High Court. It is so correctly defined. Ordinarily a senior judge would preside over the bench. The benches are declared in advance, and there is a subject-wise allocation, and which is very clear. But this new rules, frankly, I mean, I don't think that's a solution to the issues raised by the 4 judges.
Something else that emerges is that none of the top 4 judges of the Supreme Court are actually on benches which are today hearing what people consider to be important cases. I'm talking about Ayodhya, I'm talking about Aadhaar, I'm talking about land acquisition. None of the top 4 are there. Do you get the feeling that although they are the 2nd, 3rd, 4th and 5th most senior judges, they're being deliberately excluded from constitutional and important matters?
I find it really very strange that all senior most judges are kept out of all important matters. They are not there in the, as you mentioned, several matters. They are not in any of the constitution benches which are formed by the present Chief Justice. Secondly, there is another thing which I would like to mention to you, that I find that same set of judges are sitting with him. Now, what happens, I mean, I have great regard for them. They are very distinguished judges. But is it proper for a Chief Justice to pick up the same judges I find in the constitution benches? Maybe there is a 4th or 5th, maybe a different judge, but the other judges are the same.
The 2 judges who are always with him are Chandrachud and is it Khanwilkar?
Yes, I mean,
they're always there. They're always there.
No, they were my colleagues. I have the highest regard for them.
But you're saying they should be varied.
I find this selection of judges in this manner is really is not very. It raises several questions. Now, can
I ask you what sort of questions does it raise?
See, I personally believe this which I explained in B.G. Varghese lecture, because repeatedly people keep asking this question. So, what is this seniority business? What is a senior judge and a junior judge? I mean, in Supreme Court, every judge is a judge. He's not senior or junior. But the reality is that if you see, when a junior judge joins the Supreme Court or even in the High Court, for a long time he would be quiet. He would just go by the view taken by a senior judge. So seniority brings some kind of a maturity and independence, and a junior judge brings with him some, fresh ideas. So I feel that it's a mix it up. You cannot exclude all senior judges. Then you cannot just pick up some judges. They are exceptionally good judges. I have no quarrel with that. But this very idea of forming benches with the same judges for almost all important matters
denies other people
opportunities, and this also reflects on their abilities and capabilities.
And the point you're making is that if the Chief Justice always and only sits with Chandrachud and Khanwilkar, he is denying other people opportunities to mature, to learn, to gain experience. And it's important that other junior judges should sit with the Chief Justice from time to time.
See, again, a difficulty is when a junior judge sits with the Chief Justice, he's inclined to agree with him. You see, I can tell you a recent instance where a junior judge sat with a Chief Justice, gave a verdict which was completely flawed. It has tremendous repercussion. He sat with the succeeding Chief Justice and he gave exactly opposite verdict.
Because he learned. And so that learning process is what the Chief Justice is denying if he sits with the same people all the time.
Seniority has some value, and therefore even in European courts or both the courts, seniority is given some precedence.
Let's now come to the letter that the 4 senior most judges wrote to the Chief Justice in November, which was made public at an unprecedented press conference in January this year. Before I come to the contents of the letter, I want to put to you a point made by one of India's great jurists, Fali Nariman, in the Indian Express today, Tuesday. He clearly says that it was wrong for these judges to have gone public, that they should have in fact restrained themselves, and secondly, that they should have waited until the present Chief Justice retired, because matters would have resolved themselves with his retirement. Do you agree with Fali Nariman's critique? It's the exact opposite of the viewpoint you took in your B.G. Varghese Memorial Lecture.
I hold Mr. Nariman in highest esteem, but I don't agree with him. in his views, the first issue is whether the judges should have gone to the press. Now, I just give me some time on this. According to me, they went to the press because, as one writer has said, that they perceived that there was intolerable wrong in the Supreme Court. That's the reason they actually met the Chief Justice several times. They wrote letter to him, and finally, I think Loya's case was a trigger point, and finally they decided to go public. Now, what have they discussed?
Can I just interrupt and say,
yes.
In an interview that he gave me on the 7th of April, Justice Chelameshwar accepted readily that it was their anguish that made them go public.
Because, you see, I heard some people, some senior advocates, some former judges, I respect their viewpoint, they said this should have been resolved amongst the judges. So I don't see how you could resolve this problem. I mean, you have been talking to the Chief Justice. He is not prepared to take any remedial measures. So finally they said that they should go to the public. Now they have not interacted with the press. They have made a disclosure. They have not discussed any politics. They have not discussed any political issues, or they have not discussed any pending matter.
So you don't believe they did any wrong? In other words, they were pushed to do this. They had no choice.
They have no choice. And
what about Mr. Nariman's second point, that they should wait till the Chief Justice retires, because with his retirement, a new Chief Justice taking over, the problems they perceive will automatically resolve themselves?
Here again, I respectfully disagree. See, what is the guarantee that this will not recur in the tenure of the now succeeding Chief Justices? It's likely to recur again. So, are you going to wait again till the next Chief Justice?
So one man's retirement won't solve the problem. The next man could repeat the problem again.
And here I have a point. I want to say that this is the right time where all 22 judges should sit together and discuss reforms. They should discuss reforms on allocation of work. They should discuss reforms on collegium system. They should also discuss whether this MOP correspondence which is being exchanged between the government and the court, people are entitled to know what is happening. So why it is not been made public?
I'll come to the MOP in a moment's time, because it's an important issue that I want to take up with you. But first I want to come to the contents of that letter of November, which was revealed in January at that press conference. I want to discuss with you the implications of that letter. This is what the letter says. There have been instances where cases having far-reaching consequences for the nation and the institution have been assigned by the Chief Justices of the Supreme Court selectively to the benches of their preference without any rational basis for such assignment. When the Chief Justice selectively assigns cases to benches of his preference without any rational basis for the assignment, doesn't that mean that he's actually allocating cases in a way that will predetermine their outcome? That he's choosing judges that will give a verdict that he wants or agrees with? Isn't that what's implied?
The four judges, in other words, accusing the CJI of packing the judges.
Absolutely.
Or fixing the benches, packing the benches or fixing the benches. And this is a very serious matter. If there is no neutral assignment and people doesn't have belief in the Supreme Court that there is going to be a fair allocation of work, then the institution's credibility would be affected. You cannot simply brush everything beneath the carpet. I mean, you have to deal with this situation now.
Let me explore this point a little further. When the Chief Justice is accused of packing benches or fixing benches, is he doing it for the benefit of the government or the executive? Is he doing it in the interest of the government? Is there some sense in which he's beholden to the government? Because those are questions that will occur to any rational layman's mind.
See, I'm reminded of the words of Senior Justice Chandrachud. He said that there is a danger to the judiciary, serious danger to the judiciary from within and not without. So,
and this is an example of that danger.
And then many times this is orchestrated at the behest of the executive. Just keep it. This is not the first time it has happened. It has happened in the past. We have a history what happened in emergency and what happened in Mr. Rajiv Gandhi's during his government. I mean, this.
You're saying a very important thing, Justice Shah. You're saying that if the Chief Justice is being accused by his four most senior judges of fixing benches and packing benches, then the legitimate suspicion that arises is that he's doing it to further the interests of the executive, that there is an improper, inappropriate connection between the executive and the Chief Justice.
But I cannot, that would be a sweeping allegation, but this raises serious doubt about the actions of the Chief Justice.
Let me go one step further. If cases are being allotted on a preferential basis, then is justice being impeded? Is it being denied or distorted? Or would you say it's still being delivered? Which of the two?
No, it is being seriously impeded. See, if there is no neutral case assignment, there is no guarantee of justice being done in a fair and proper way. So, if either it has to be done in a or there will be always a perception that the cases are matters are assigned to benches in a particular way to influence the outcome.
So two things are happening as a result of what the four judges called preferential allocation to preferential benches. One, there is a suspicion that in fact it's being done improperly to benefit someone. That someone could be the government or someone else. And the second is that in the process, the net result is that justice is being impeded. Both things are happening.
Yes, I agree.
In which case, let me ask you this. Are there grounds for seeking the impeachment of the Chief Justice? Because these are serious questions about his integrity and functioning.
So I do not wish to comment on the impeachment because really I don't know. Because I heard that some motion has been prepared, it has been signed by some MPs.
And then sidelined.
But this is not I personally feel that the impeachment is...
Leave what politicians are doing out of it. Let's leave politicians out of it. I'm simply asking you, the doubts and suspicions about the Chief Justice's integrity and functioning are huge. You've agreed. Are there now moral question marks about his suitability to continue as Chief Justice?
There are question marks. I feel that this is a time where as I said, that all judges must. I mean, why only a CJI can call the meeting? There should be requests from the majority of the judges to discuss these issues. I mean,
let me raise something else with you. The letter of November, which we are discussing, written by the four judges, which was made public in January, not only raises serious questions about the integrity of the Chief Justice, it also actually casts aspersions on the performance of some of the junior judges, because it suggests that they are pliable and that they are willing to do the Chief Justice's bidding in a way in which perhaps other judges are not. That's another implication of that letter.
I'm not suggesting that the junior judges or some other judges to whom the matters are assigned are pliable but this whole sequence of events, I mean, create doubts about it. I mean, it should have been avoided. Even now, I find this is being repeatedly done. I mean, there is no change in the.
Let me put it like this: there are serious doubts that have been created, not just about the Chief Justice, but also about some unnamed junior judges. Both parties have doubts now and question marks hanging over them.
No, this is the unfortunate outcome of a principle, so-called principle, that the Chief Justice is the master of the roster and he has unbridled discretion to allocate the work. This could have been avoided by bringing in some proper systems, which unfortunately has not been done.
Before I move to another subject, let me put this to you. Has this whole episode and the doubts and question marks that have risen about the integrity, the moral functioning of the Chief Justice as well as junior judges, has this damaged the reputation and image of the Supreme Court in the eyes of the Indian people?
Of course. Talk to any comment. I mean, sometimes people blame the four judges for going to the press. They said that they should not have gone, what the common man would think about the Supreme Court. But in the process, whether they are right or wrong, justified or not justified, in the process, the credibility of the Supreme Court is seriously affected. And it's high time that the judges should really take some steps to rectify the situation.
Let me now at this point, Justice Shah, come to another letter written this time by Justice Karan Joseph. I believe it was written just a couple of weeks ago. It was sent not just to the Chief Justice, copies were given to all the other judges on the Supreme Court as well. And he points out that more than 3 months have passed since the Collegium recommended the names of Justice K.M. Joseph and Ms. Indu Malhotra to be elevated to the Supreme Court. And yet, although more than 3 months have passed, the government hasn't responded at all. Not a word from the government. And Justice Karan Joseph writes in that letter that this silence threatens the very life and existence of the Supreme Court. How do you, one of India's most eminent retired judges, view the government's deliberate silence? Because it is deliberate.
No, in the first place, I find that this is I mean, first time ordinarily a recommendation for the appointment of the Supreme Court would be cleared in 2 to 3 weeks. It's, as far as my memory goes.
This is over 12.
Over 12 weeks, and there is no response from the government. Now, I heard that one of the objections, these are just the stories circulated, that he's junior in the All India seniority list. But that's not true. There have been several instances where the Chief Justice has been picked up, though as a Chief Justice is senior, but as a judge he may be junior in the All India seniority list. Secondly, Justice Karan Joseph is going to retire. So there is going to be no representation. There won't be any representation for Kerala. So what is the objection to Justice K.M. Joseph, except that the executive doesn't want Justice K.M. Joseph to be elevated?
Let me tell you what most people believe. Most people believe that the government is deliberately sitting upon these recommendations because they don't want to elevate Justice K.M. Joseph, because as Chief Justice of Uttarakhand, he was responsible for reversing the dismissal of the Uttarakhand government. Do you share that belief?
That's a perception of many. But I have got a slightly different take on this. According to me, the executive is sending the message that if there are adverse judgments, so perhaps the career progress could be threatened. It could be thwarted by the government.
So the message the executive is sending by not accepting Justice Joseph's name is that, listen, judges, watch out. You give adverse judgments, your career will suffer.
This is how I perceive this. Otherwise, I do not see any justification. And why there is no response? If the government has any objection, as per the judge's judgment, the government must write to the collegium at the earliest, and if the collegium reiterates, then the appointment has to be made. So why there is no response, and why the collegium or the Chief Justice of India is keeping silent? Why the collegium has not written to the government, calling upon the government to give some explanation for this long 3-month silence?
I want to pursue the point you're making about the collegium not pursuing the matter. On April the 7th, when I interviewed Justice Chelameshwar, he readily admitted that not only has the collegium not reiterated these names, but it hasn't even been in touch with the government to find out why aren't you passing it. In other words, the collegium has done nothing to pursue the matter. What do you make of that attitude by the collegium?
See, bit by bit, the Supreme Court would be surrendering its power of appointing the judges, or have a primacy in the appointment of judges by their actions, or I would say even inactions.
So the Supreme Court, you suspect, is buckling under pressure?
Sure. No, I'm not saying, but their inaction might lead to the effect that would question about it would raise questions about their primacy in the matter of appointment of judges.
In this context, let me quote to you what the Supreme Court put up on its website on February the 2nd regarding specifically Justice K.M. Joseph. I'm quoting.
Yeah.
The collegium considers that at present, Justice K.M. Joseph, who hails from the Kerala High Court and is currently functioning as Chief Justice of the Uttarakhand High Court, is more deserving and suitable in all respects than other Chief Justices and senior puny judges of the High Courts for being appointed a judge of the Supreme Court of India. Those are critical words. Is more deserving and suitable in all respects than any other judge. If that is their belief and they've put it in public, don't you find it strange they've done nothing to pursue the matter? They've just accepted the government's refusal to respond and they've done nothing more.
But Karan, it's not only these two appointments. The appointments are being stalled in various high courts. For example, Calcutta, it's a court with 72 judges or 70 judges, and there are only 30 or 35 judges. The appointments are blocked all over. So, and then you remember that.
And you're saying in each case the collegium is doing nothing about it?
No, the collegium is initially the then Chief Justice, he wept in the presence of the Prime Minister or shed tears.
Weeping doesn't change political minds.
Doesn't change. And perhaps the only way to resolve this issue is, as suggested by Justice Kurian Joseph,
take it up
judicially. There is no other way you can resolve this problem. So if the executive decides not to respond, not to accept the recommendation of the collegium, the only way is to deal with it judicially.
And if the Supreme Court does not accept Justice Kurian Joseph's advice, take it up judicially, then you're also suggesting that they are indicating to the executive that we're prepared to buckle, we're prepared to accept your dictate.
I find it very strange that there is no questioning of the government by the collegium in spite of the...
This is one instance when the collegium should be strong and determined and resolute.
Of course, I agree with you.
Is there any suspicion in your mind that the reason why the collegium is not strong and determined and resolute is because the Chief Justice doesn't want to be strong and determined?
No, I'm not sure whether he doesn't, because he recommended the name. But what I find that I can say one thing, that unfortunately he's unable to give that kind of a leadership to the court, to the collegium, which can unitedly take up with the executive.
So this has also become a question of the leadership the Chief Justice is giving.
Of course, that's a very serious issue.
His leadership is not up to the challenge at the moment.
Of course, is not up to the challenge, because just look at the way the four judges approached the press. Their letters have been written. He has not reacted to that, but anyway, he's unable to control the affairs of the court.
So his handling of all the different issues over the last few months has also undermined his personal stature.
It's not satisfactory, this much I can say.
It's not satisfactory.
Of course, it's not satisfactory.
Let me now come to my last issue. It's to do with a couple of suggestions made by Law Minister Ravi Shankar Prasad to the collegium for inclusion into the memorandum of procedure, which, as you know, is presently being painfully negotiated by the collegium and the government.
For the last 2.5 years.
For the last 2.5 years. One of the things the Law Minister wants included in the memorandum of procedure is what he calls a screening committee mechanism to select candidates before the collegium recommends their names. Do you think a screening committee mechanism is a good idea?
A screening committee mechanism was suggested in one of the judgments in NJC case. So one of the judges suggested this mechanism. But this was in a very vague terms. So what is that screening committee? Who would constitute the screening committee? Is the screening committee going to pick up the candidates, or the candidates nominations would be made, and then the screening committee would inquire into that? Who will make the appointment to the screening committee? The collegium? Whether executive will have any say in this? It's very easy to float the ideas, but I have not understood how it's going to work, this so-called screening committee.
So without any of the details that you say are necessary, this is a facile idea.
Yeah.
It's easily floated, but it doesn't amount to very much.
No, nothing. And yes.
Let me then come to a second suggestion made by Law Minister Ravi Shankar Prasad. He says the government should be informed of the criteria on the basis of which recommendations are made, and he also says the government should be told of the number of people in contention from which the recommendations are made. Do you agree with either of those?
No, I did get it.
One, he says the government should be told on what basis, what are the criteria for recommendation. And secondly, he's saying the government should be told how many are the total number of people in contention before you start recommending names.
No, that's the second part I do not agree. It's not necessary.
Criteria?
But sure, the criteria, I feel that the criteria, I'm not saying criteria should read like a laundry list, that he should be man of integrity or whatever, I mean. But there should be a proper scrutiny of his credentials. If he's a judge and to be elevated to the Supreme Court, you may look into his judgments, look into his disposal and many other aspects. If he's from the bar, look at the how many cases he has conducted. I mean, what is his research on the law. So there can be, you can lay down the criteria. It's not easy, but that's on the other hand, I feel that it's not a bad idea to have some definite criteria, but they will be flexible, but they can be kept in view.
Thirdly, it's now well known that the government is insisting on the right to reject collegium recommendations on the grounds of national security. In the interview he gave me on the 7th of April, Justice Chalameshwar says he has no problem with that, provided two things. One, that the full national security concern must be shared with the collegium, and secondly, all supporting evidence must also be given to the collegium. Where do you stand on this tricky issue?
See, I agree with Justice Chalameshwar. I mean, government cannot simply say that a particular candidate is rejected on the ground of national security. They must support their claim by solid evidence. They must indicate the reasons. But my fear is, by putting this clause, really executive is trying to get a veto in the matter of appointments to the higher judiciary. That cannot be accepted. Even this suggestion of this very bogey of national security, according to me, is created just to get the last word in the matter of appointment. Because they lost the primacy as a result of 3 judges' case. NGSC was declared unconstitutional. So this is, according to me, this is a backdoor attempt to get the primacy which was taken away from the government.
And that cannot be accepted.
That cannot be accepted.
Finally, Law Minister Ravi Shankar Prasad says that after 20 years, a time has come to audit the functioning of the collegium. And when I asked Justice Chalameshwar on the 7th, he says he has no problem with that. Do you think an audit of the functioning of the collegium is a good idea?
See, it's my personal view that the collegium is completely, the very system is completely flawed. It's very undemocratic. The judges appointing judges, I mean, frankly, I'm not in favor of any collegium. The Supreme Court had a terrific opportunity when they heard NJSC case to either amend NJSC law to read down certain clauses and make it very, I mean, safe, or have the judges' primacy to be retained, or I mean, they could have themselves reformed the collegium system in a big way.
They did neither.
They did neither. They rejected. They declared the NGSC unconstitutional, and they left the work of making the reforms to the government. That was not a good idea.
Mistake.
That was a serious mistake.
So in these circumstances, you think that an audit of the functioning of the collegium is a pointless thing to do?
No, it is, if it goes, I mean, hopefully, if this matter is looked by a larger bench. Again, I'm larger bench should be constituted by of senior judges. I mean, again, the constitution of larger bench should not be used to dilute the judges' cases or the judgment in the NJSC case. But if a larger bench is constituted, surely it can look into the flaws of the collegium, how reforms could be introduced in the collegium, even without the support of the government.
Is this an urgent need?
I mean, it's an urgent need. I would say that because the way the collegium functions is not really, is less than desirable. I would say that there is a need for bringing some reforms in the whole process of appointment.
My last question. There is some apprehension that Justice Gogoi, who according to seniority should succeed as Chief Justice of India when Justice Deepak Mishra retires in October, might not be recommended by Justice Mishra, and as a result of which, he won't become Chief Justice. And you know, in the past this has happened as well. And the reason people say this could be the case is because he was one of the 4 judges who wrote that letter, and therefore he was also one of the 4 judges who held that press conference. Is there any fear in your mind
No, if this
that
happens,
he could be superseded?
if this happens, I would say that this is the blackest day in the history of the Indian judiciary. If this happens, I can only say this. I hope that this will not happen. Mr. Nariman also said that this will not happen. But the fact that the name has to be recommended by the outgoing Chief Justice is matter of some concern.
Justice Shah, a pleasure talking to you.
Yes, pleasure is mine.